Okay, so this is the session, right? Second session for law optional UPSC 2025 question paper solution. Now, as you know, 3 days before I discussed law optional paper 1 of 2025 solution. Now, if you look at the paper 2 of this year's law optional paper, you will see that the first question that was in question number 1A was doctrine of foreseeability and proximity is a correct test for remoteness. Explain with the help of case law. Now remember, it is a very famous Wagon Mound case, right? Whereby the foreseeability was considered to be a better test, right? So what you have to do, you have to literally first talk about a person cannot be blamed for unlimited consequence of his act. 2, 3 philosophical lines, and then you talk about okay, there was a direct text and there was a foreseeability test, and ultimately the foreseeability test was adopted by Indian courts as well. Okay, Wagon Mound, very famous case, you must be knowing it. If you go to the paper, this law optional 1B, no, not nervous shock. 1B, it is saying the definition of public servant as per the Prevention of Corruption Act 1988 is only illustrative, not exhaustive, right? Now, there can be single line answer yes, but obviously you can't write yes, that is the case. But what you will do, you will talk about what was the purpose of the Public Servant Act. You will say that how IPC was unable to handle it, hence this law came into being, right? And then you will talk about the definitions that is there in the Public Servant Act. Okay, now the definition itself in the Public Servants Act, if you know, sorry, Prevention of Corruption Act, if you go and see, it is itself 2 pages long, right? So that itself will be 150 words, but obviously you will have to sort of make it much more better, right? You will have to make it much more little bit condensed. Okay, now if you go to question number 1C, you will see it says salient feature of the Protection of Civil Rights Act, very repeated question. Again, I have also asked it. Last year also asked in test paper. This year also asked in that law optional UPSC test paper. Right now, the structure that you have to write in this answers is basically, you have to talk about social disability, points and sections, economic disability, points and section, religious disability, point and section. Okay, so instead of writing just sections, you have to club them into different type of disability. Okay, that is one of the feature you can talk about. Same thing happens whenever there's a question of SC/ST Prevention of Atrocities Act also. There also the disability has to be written in that structured manner. Okay. Now, let us come to 1D. It says, explain the principle of the master of tort committed by servant right case laws, right? Principle of liability, right? So it is basically talking about vicarious liability. So first you will talk about rational, right? Respondent superior, or the public policy dictates, or there's a very famous concept whereby those who do act through another must take the responsibility, right? So we write these are the 3 rational, and then you will go and talk about a specific relationship between master and servant. Okay, now do not confuse it with the state vicarious liability. Okay, that is not there here, and it is a 10 marker question, so you will not have time to write exceptions, but if you can squeeze in exceptions, that will be also quite okay. Then come to 1E. It says, under what circumstances can appropriate government commute sentence of death and life imprisonment from any other punishment? Now this question was a very unique question, because this actually relates to CRPC, not IPC, but still they have asked it. So what I can suggest here, that you're going to write, obviously the assumption is that you must not have studied CRPC, right? But still, what you can do is that you can sort of talk about the kind of punishment that is provided under the IPC, and little bit constitution you can here talk about. Okay. Otherwise, this question really, is in domain of mostly CRPC, right? So this was a sort of a bouncer. I always say 1 bouncers are almost there, but still, if you write what I suggested, not 6, but at least 3, 4 marks you will get, right? So it was not something which you totally don't know, right? That is obviously not the case. Now, the most typical question, culpable homicide and murder, no matter how much, unique lines they write, ultimately the question is between culpable homicide and murder, or technically speaking, culpable homicide not amounting to murder and culpable homicide. Now, if you look at it, I always say, the copies who are the student here, they must be knowing. I always say that how to write the answers like this. So what you do, you make a, in your page, suppose this is the page. What you do, you write here 299, 1, 301, and then you first write both the sections and then write the cases on the keywords, right? Then write the cases on the keywords, then come to the 299, 2, 303 and 4, 2 and 3, sorry. And then you know, write on the cases on the keywords in natural course causing death, okay, in all probability cause death, right? So on those words, you have to write the case law, right? So that is the best way to write this culpable homicide and murder question. Okay, chill. Let us come to next question, that is 2B. Now, this 2B question is again a very interesting question in the sense that it actually talks about what is the right of private defense. So we have to talk about the rationale of the right of private defense. Now, you must be confused that whether you will write BNS or IPC, right? This is a question which is generally, almost every time a student used to ask me. If you look at this question, you will find that in these questions, IPC questions, what I have suggested that in the introduction part, you write IPC/BNS sections, and then, go on about writing IPC only. That won't make a difference. Because think from the perspective of a teacher, right? He have been studying, that professor have been studying IPC for last, 40, 50 years of his life, or 60 years of his life or her life. But suddenly BNS section, she also might not remember, right? So writing that in the intro part and then talking about only IPC would be, I think, sufficient. But even though if you write BNS, that is also sufficient. That is also not wrong per se. Okay, because anyway, the IPC is still law, but still, that can be written. Now, what is this right to private defense must be? So it means they are talking about the grounds on which the right of private defense can be challenged. I mean, you can be denied to give them, right? You cannot exercise them excessively. It actually only is acceptable. It is only acceptable as and when your as long as the threat recedes, your right also recedes. Okay, if you have a recourse to public authority, the right do not apply to you, right? So the multiple section in IPC. So you have to write those sections in one cases if possible, because this is 15 marker question, so 3 pages you have to write. Okay, yeah, proportionality, very correct. Right. Now let's come to nuisance. Now nuisance is no branch of negligence. Explain and describe who can sue and who is liable for nuisance. Now, nuisance initially was considered to be a branch of negligence, right? Because of my negligent behavior, it is causing some discomfort to you. But later the jurists have started to say that no, it is not a branch. So how to go about it? So you simply write, go with the question keywords, both are different torts, and then talk about nuisance. See, the question is about nuisance only. This is only you have to sort of say, okay, these are two separate branches arising out of different conduct of an individual. Then you have to simply talk about the nuisance. Now, nuisance, all of you must be knowing, yeah, two type of nuisance, public nuisance, private nuisance. Public nuisance are always a crime. But in certain cases, if certain conditions are fulfilled, like, for example, if you can have a special damage, it will become, yes, Maitri, it will become a tort as well. Okay, so again, very simple question, not a very Radhe Syam Tiwari versus the very famous case in that also. Okay, let's come to 3A. Discuss the law of defamation. Is this correct to say that the law of defamation gives too much protection to reputation and imposes too great restriction on freedom of speech? Comment. Now again, this question is of tort or constitution. So obviously this is a question of tort, right, rather than the constitution. But still you will have to write Article 1918. Okay, because Article 19, one of the reasonable restriction is actually defamation, right? So the interplay between them, yes, interplay between them, that also obviously we'll have to mention, and along with all the exceptions that is there, right? So almost there are 10 exceptions in defamation, if you remember, criminal defamation specifically. So all of them are now more or less the same thing applies to the tort as well, right? So all those 10 has to be written. Again, it was a repeated question. Yes, someone is saying very correctly. I have asked in the law optional test series here. This is I do, last year also law optional test series I have asked this question, but last year this question was not in the UPSC law optional mains, but still, yeah, the question I have asked. So this is something which is very repetitive, right? It is something which is very, very repetitive. Okay, the law of tort is said to be a development of maxim ubi just CB remedium. Again, this year also have asked, last year also have asked this question, right? This is a very typical question. See, if you have a question of law of tort versus torts, or the one theory try to restrict them, right? Pigeonhole theory, or this, ultimately the answer of all of them remains the same. You see, what is the purpose of the tort? The purpose of the law of tort was, some twisted act has occurred in society, and you are at the receiving end of that twisted act, then the And if there is no law with regard to it, right? Parliament has not taken any cognizance and there is no statutory law with regard to it, then where will you get the remedy? That is where this, law of tort comes into the picture, that you will have remedy in tort law. Okay, so that is why it is a very interesting. Yes, very correct. Salman versus Winfield theory. Okay, now let us come to 3C. Now it says, critically examine the provision related to few major offences which fall upon sovereigns against mergers in criminal law of India. Support your. Now see, here the word is criminal laws of India. Now, is it talking about IPC only? Right now, you can take two approach, because there is a separate chapter offense against marriages in the IPC. So either you can write those itself, or if you want, you can always go to the Domestic Violence Act, that also have the provision with regard to offense against marriages. So I always suggest that rightly main IPC, and then in the in the last bottom, if you want, you can say the other laws also which provided for the offense. There are two major laws basically. One is the Domestic Violence Act, and second is the Prevention of Dowry Protection, right? So those are the two major laws that obviously you can sort of add them. Yes, very good. Okay, now dacoity is an aggravated form of theft and robbery. Now this year I thought that this question will come. Okay, because last year this question was not there, right? Like if I remember, I think Kalas is right? 1B itself, I have asked this question this year, law of contest series, right? Every robbery is the theft. This is a very typical question because last year it was not asked. So I had a hunch that this time that might ask. Now again, this is a repeated question. There is nothing unique about it. This is a very repeated question. Okay. 4B, in case of a joint offender, their liability is joint and separate. Now, one of the students actually messaged me, sir, this is a crime question. No, this is a tort question with regard to joint tortfeasors. This is a tort question with regard to joint tortfeasors. Hurleen IPC, I have already discussed Hurleen. I think, Acha, you joined late. I told that mostly, in the introduction, write both of them, and then your choice, either you go with the IPC or BNS. I don't think that will matter much. Okay, but in the introduction part, in law of paper, as the this have changed, you try to write both of them at least in the introduction part, /BNS/IPC. Okay, then come to 4C. Now, this was something of a bouncer this time, right? Consumer Mediation Cell. This was a recent development. Now, the two recent development in the Consumer Protection Act, if you remember, one is the Consumer Protection Authority, right? And the second is Consumer Mediation Cell. So, Consumer Mediation Cells are basically at three levels: state, union, and district level, and it works along with the Consumer Court. The Consumer Court can ask for mediation, and then it should come to the Consumer Court, right? So, sort of a pre-litigation stage it has turned up. So there's a specific section, I am forgetting the exact section, but there are specific sections which provide for the fulfillment of, this consumer mediation cell, making of consumer mediation cell. Now, obviously that section itself is, 1-2 line, you can literally say there will be consumer mediation cell, but there are certain functions of that consumer mediation cell. Okay, so that functions has to be written, but still that will not fulfill your, 350 words or 400 words. So what you do, you can simply, sort of write that how mediation is helpful in solving disputes in general. So that can act as a filler here. Okay, because this section is very small section, hardly, in one page it can be over. But obviously you have to write generically that how mediation is going to help it. Yes, someone is saying we are section 74. Yes, that might be correct. I don't remember exactly right now. Okay, now let us come to question number 5. That is your, the CLD and this contract paper. Now, law as well as justice should prevent unjust enrichment, right? Section 68 to 72, right? Now, specifically, if you remember, there's a very famous case of BK Mondal, right? Very famous case. Now, that case is not only famous for the purpose of unjust enrichment, but that case is also famous for sovereign and non-sovereign function. In that case, what actually happened? If you remember, there was a executive engineer who asked that contractor BK Mondal to build some home. Now that home was built and the government was using it as an office. Later they refused, saying that there was no contract, there was no publication of notice, etc., etc. Now they were using it, obviously it is a commercial nature, but there is a very interesting point that happened, that the government tried to take the defense that, see, any act of the government of India or the government of West Bengal in that particular case has to be done in the name of governor. And there's a proper procedure as per the constitution that has to be done. That was not followed, hence the government liability do not function. Then the court said, no, this is simply a contractual dispute. Do not, put constitutional law into it. Just to deny someone money, right? Because that office which was built was basically used. It was considered to be a non-gratuitous act. if you remember the sections. Okay, anyway, again, a very repetitive question every time they ask. In that, they sometimes also ask, with regard to your, if you remember, that necessaries supplied to a minor, that section is also there here, right? So that is also something you could have written here. Okay, now 5B, let us see. Now, if you look at 5B, now 5B is again a very interesting question in the sense that it says, in the breach of the sale of contract, both buyer and seller have remedies against each other, right? So right of an unpaid seller, and indirectly they have asked, right? And buyer with regard to risk. What will happen, if you supplied it wrongly, or, it has destroyed in between, right? So both the component has to be handled, like the risk passes along with the property and right of an unpaid seller, right? So the table, unpaid seller, what they can do, lien, sell in between, stoppage, right? Stoppage in transit. So with sections, you have to simply make a table and simply describe it, right? Again, a very easy question. It is really of a 10-marker question that they have asked. The 5C, it says the outgoing partner shares subsequent profit, but not the liability for the act of the firm under after his retirement. Illustrate the statement with relevant provision of the Indian Partnership Act 1932. Now, if you remember, what is a partnership? Now, the very core, now remember, partnership is the oldest form of business entity, right? Now, if you remember, the liability of a partner is only when that partner remains in the partnership firm, right? So, you can have a clause in the Partnership Act saying a partner is going away, but he will share profit. Why? Because there is something called goodwill in the partnership. Like, for example, today, I know I'm suppose a very famous member of a law firm. Now I goes away and tell to the partnership, and that law firm is a partnership firm. I tell them that, okay, see, I'm going away, but you can use my name. So you're using my goodwill. So you give me profit. But merely giving profit does not mean that I will also take upon the liability. For me to taking away the liability, I must be the actual partner of the firm. Right? So profit can be shared by the outgoing partner, but not necessarily the liability. Right? So again, there's a specific section with regard to it. You can very easily write it. Similarly, if you come to 5D, the role of a certifying officer. Now, this is something of the IT Act, whereby last year they have asked you controller of certifying authority, right? Controller of certifying authority. This time they have asked about the role of certifying officer, right? So these, they are saying that, see, they are not doing a quasi-judicial function. There's particular ground for you to ask for a license. Now, once that ground is achieved, okay, you have to simply give the certifying officer have to simply give the license. They cannot come and say, "Nay, I think that you will be a bad businessman." No, you cannot do that, right? So their power is more of an administrative in nature rather than judicial. So you cannot decide upon. So if the criteria that is provided for the someone asking for a this issuance of digital signature, you simply fulfill that criteria, it has to be given, right? So your function is merely administrative in nature. So again, a very simple question. That is why it is in 10 marker. Now, this is something, one of the students told me, sir, I studied the entire IT Act by, I did not study this portion, and that was only asked. So UPSC, tend to do that, obviously. Now, public interest litigation is a tool to protect fundamental right of person or group unable to approach court due to poverty, social and economic conditions. See, I told you, every time in PIL, make 4 different area. Social justice, then police reform, prison reform, you can say. Third is environment, and fourth is elections. And remember, at least 5 cases in each of them. And now the question comes, PIL is a tool for strengthening democracy, right? The social justice election cases. PIL is a tool which brings, people and court together, right? The cases related to social justice. So this is such a typical, and if the PIL has changed the environmental jurisprudence landscape in India, right? The cases related to environmental jurisprudence, right? Like this, this is the second question that I gave. The law optional test series also have given this question. The PIL brings judges, courts and society together, right? Closer. Right? So again, social justice cases has to be put up, right? So again, very typical, right? Very typical. Now let us come to 6A, 20 markum. Every agreement for which anyone is restrained from exercising a lawful profession, trade, or business or any kind to that extent is void. right? So restraint in trade is void. Obviously, there are a lot of exceptions, such as franchisee agreement. Again, this question again I have asked this year also. If I remember, I think paper 2 itself, 5C, right? So it is international law paper. This paper itself, full length paper, I must have, this legal proceeding, I have asked it. See, the object of protection of Civil Right Act is, the question was, what are the various provisions of the Civil Right Act? That was the question in this paper, right? But still, this is a full length, test, obviously. Now, this is not surprising because every time they repeat it, not to worry. This is defamation. Then come to, there was a question I remember. See, culpable homicide and murder. Every time I repeat it, every test, and they ask the same thing. Right? Like this student also have explained the same thing in his paper, that right answer like this. Okay. Same explanation, if you remember, right? That I explained you. Try to write the answer like this. That is a much better approach. This Kala's very good student. He might qualify this year also. Okay. तो ये कहाँ गया भाई? Where is the paper 2 में होगा ना? It must be in part B. Is patent one. Exemption clause. I must have asked somewhere, anti-competitive. Unpaid seller, right? This is again one of the questions that was asked, if you remember. What is the right of an unpaid seller as well as buyer? Dono ka tha, but the question here is only half of unpaid seller. I have asked it, I remember. Check the copy, somewhere it must be there. Yeah, so isme see, because every time, for law of contract, I take an entire paper, test number 7, and 4 full length. So in that, 2 of the entire syllabus one, right? So in that also there are 2 paper, right? So out of the around 70 question I ask you in the contract itself, right? That is, I think, beyond that, it is very tough to get questions. I'm getting it. It is in C. Somewhere it must be there, right? So in any one of the question, right? It must be there somewhere. Let us first start with the paper, then they can. Okay. Now, let us come to 6B. Now, 6B says, any departure from offer and in relation to any qualification accepting offer vitiate the acceptance unless it is agreed by the. So, there is basically offer must be absolute and clear, right? So, that is the question. Okay. So, you can give multiple examples with regard to that. And acceptance also must be absolute and clear, right? So, again, multiple example can be given, right? You can counter offer are different, cross offers are different. Okay. So, those are example you can very easily give. Again, very easy question, very repetitive. In that, there is last year they asked the question, offer and invitation to offer, the law optional paper of UPSC. Okay, now the law of coercion, such and such last line, blah 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 blah. But the main question is distinguish between coercion and this undue influence. This is the main question. So I always tell in our test series also law optional that leave the prelude, only consider the actual question. Only consider the actual question. So this is the actual question. What will happen? What are the presumptions raised? Now, if you remember, you must be knowing that in the case of undue influence, once that position of authority is proved, the burden of proof shifts. Right? Once the position of authority is there, right, the burden of proof shifts. So that is the question basically they wanted to know. Right? Now again, very easy. Now here, this part actually, the first part, there was a case whereby an old person was actually unduly influenced. Now the question was that coercion can be a physical coercion or mental coercion as well. Now obviously it can be a mental coercion, right? So the question is basically difference between undue influence and coercion. Again, quite, and the presumptions. So I told you the main presumption is in the case of coercion, the burden of proof, undue influence, the burden of proof shifts. Okay. The party of a contract must either perform or offer to perform their respective promise unless the performance is dispensed or excused under the provision of the contract. And explain the statement. Basically, it is talking about the performance of the contract would become a discharge of the contract. Now, what are the kind of performance that you can perform, right? So, performance with regard to time, performance with regard to execution of work, right? So, there are multiple ways of performing the contract. So, you simply have to write different sections, ways, and then in bracket, case laws, one case laws in each one of them, right? So that will be again sufficient for it. Again, quite an easy question. Last year, like there was a question, code and non-code obligation of the contract. Like again, that was not the question. Now let's come to 7B. It says both horizontal and vertical agreements are included in the section 3 of the Competition Act when horizontal agreements are considered more harmful in the comparison, right? So horizontal and vertical agreements under the anti-competitive agreement, the example given, both of them example, you can cite the examples. One thing here you can include is the factor which will be considered by the Competition Commission while determining vertical and horizontal agreements. Now in that, geographical area becomes a very important factor, right? So relevant geographical area and relevant product. Okay? So the product and the geographical area. In that also there are a lot of cases not needed. Here focus mostly on the agreement itself. Now let us come to the 7C. It says the precautionary and polluter pay principle. Now if I remember correctly, this year I have asked in one paper pollution pay, and in other paper I have asked this not this precautionary, I have asked that public trust doctrine. So there are 2-3 major doctrine, right, which is there. How the horizontal agreement is, horizontal agreement actually gives you much more power to go and see, because what is the horizontal agreement? Okay, so vertical agreement, as you all know, vertical between companies. Horizontal agreement, what happens when a person comes, a competitor comes, they basically interact you with with your company horizontally more. ठीक है, मान लीजिए if you are selling something, तो आपका जो trade channel है, the trade channel that you are having, तो फिर कोई आके उसमें बेचे, ठीक है, तो वहां पे if you have an agreement with them कि हाँ भाई आप इसका प्रोडक्ट नहीं बेचेंगे, सिर्फ मेरा बेचेंगे, that is more dangerous. ठीक है, vertical भी dangerous obviously, but that is more dangerous, उसका impact तुरंत आता. That is why the horizontal is more dangerous. Okay, can so again वही है, both of them explain with few philosophical lines कि what is the polluter pay principle, what is the precautionary principle, to err is the human right, something like that, good lines, and then 1-1-2-2 cases in each one of them. Right now, all of the time I suggest to differentiate your answer, because everyone will write the same. To differentiate your answer, what you can do, if you remember in the foundation batches, the optional foundation batches, I used to say kisi always start with a new international Stockholm conference, a different principle of a Stockholm conference, and then say okay, so and so principle provide for the same. So that makes your answer a little bit unique. Okay, so that you can do, otherwise question again is very repetitive. Now 8A, it says right to information for citizens to secure access under the control is important enactment. Now again, it is a prelude, leave, also discuss the obligation of public authority, right? Now that is the main question. So first is the philosophical part, merely KSS, very important. It is like sunlight is the best disinfectant, right? So more of a GS kind of thing. Then second point becomes very important, obligation of the public authority, right? Proactive disclosure, you will weigh public opinion, public function in such a manner that this act, the whole structure of this act is to sort of, dismantle the clock of security for public, clock of security which is guaranteed under the different laws of India with regard to public servant, right, such as Official Secret Acts. So basically, this is sort of to empower public officers not to get afraid of the official secret. Okay, so those 3-4 philosophical lines, and again, the entirety of the sections you can write. Then come to 7B, 8B, sorry, it says to enforce arbitration agreement, the terms of agreement must be clear and certain. Now, there was recently a case laws with regard to that in current affairs also given, whereby the court have said that what do you mean by certain agreement? Certain is something which is either certain right now or can be made certain at a later date. So the future certainty is also the certainty. Like for example, the case was specifically, okay, I will do a contract and I will make the number of school I'll decided by the cabinet or by a particular authority in 2025. Now, as decided by that authority, now that was not certain. So the authority decided 200 schools should be made. Now the question is, can that arbitration agreement be valid whereby this certainty is not there? Then the court said that no, it include both current certainty and future certainty. So certainty do not mean that it has to be certain right now. Okay, so the court said, see, the entire premise of any kind of commercial legislation is to facilitate the commerce, right? The purpose is not to restrict the commerce. So the interpretation of the law should also be made in a manner that it facilitates the commerce rather than restricting, right? So that philosophical line along with that case, right? That is also sufficient. Now discuss the remedies for infringement of trademark and passing off available to a trademark owner. Now, this is also asked, what is the remedy major infringement of the trademark. And now, once you are infringing the trademark, the remedies are basically two, judicial remedies and non-judicial remedy. Now, in non-judicial remedy, we have tortious remedy. Now, you cannot say it is a non-judicial remedy, it is a non-statutory remedy sort of, right? So that is called passing off. Okay, so that passing off. Now, remember, the passing off is an extra remedy which is not there in the part of the Trademark Act, right? So the trademark is unregistered. This is basically a tortious remedy. That passing off is basically a tortious remedy. Okay, so you can, first talk about the statutory remedy, fines, punishment, all those things. And then you can talk about, okay, tort and passing off. You can simply write a heading, tort and passing off, and then talk about how passing off can be considered as one of the remedy if the trademark is not registered. If they are registered, no need to go for passing off. Mostly there are a lot of stringent provision in the Trademark Act with regard to remedies. But if your trademark is not registered, then the passing off becomes the only remedy. Okay, that is very important. So again, this year paper, law optional UPSC 2025 paper was paper 2. One I have already discussed, so this was the paper 2 discussion. Now let me open the floor for you guys to ask me any questions that you might have. Yes, please go ahead and ask me questions. Otherwise, we will simply wind it up. Anyone? For 5 minutes, not more. First, you study Mathri, what is vertical and horizontal agreement. I think you are getting confused. Yes, anyone else? Mathri, you already student. I will discuss with her later also. That is not an issue. So wind up करते हैं फिर आज के लिए. Yes. Divyansh, Divyanshi, Harleen, Hers, everyone understood? So wind up करें फिर. Or any question you might have? No. Chलिए, let us wind it up. Thank you.